Greeting to all friends. My name is Alex Naong Felix Sitom. For today's presentation, I will be covering the introduction and fact of the case as part of our group assignment. The case we selected is Winston Tang Chun Leong against 7 Autospa Holding Sdn Bhd. This case was heard at the Industrial Court and it focused on an important issue in employment law, which is dismissal from employment. In my part, I will give an overview of Malaysia's employment law, the citation of this case, and explain the key facts that lead to this legal dispute between the employee and the company. These are the members of our group. Introduction. Employment law in Malaysia is mainly governed by two important laws, the Employment Act 1955 and the Industrial Relations Act 1967. In 2023, the Employment Act was amended and expanded to cover all employees, no matter their salary level. This case highlights three main issues: whether there was wrongful dismissal, whether the employer followed the correct procedures, whether the employee was given a chance to defend himself, which relates to natural justice. The method used for this study is doctrinal legal research, meaning we analyze statute, decided cases, and journals. The Employment Act 1955 set out minimum term for workers such as a leave, notice of termination, and basic benefits. The Industrial Relations Act 1967 deals with disputes between employers and employees. One very important section in Section 20 of Industrial Relations Act, which allow employees to challenge unfair dismissal at the Industrial Court. 1 January 2023, the Employment Act was expanded to apply to all employees, regardless of their salary. This means that every worker in Malaysia is now protected by the Act. At the same time, this also places greater responsibility on employers. If an employer wants to terminate an employee, they must follow the correct legal procedures. If they fail to do so, the termination may be ruled unfair by the court. The case we are discussing today took place after this amendment, which make it highly relevant. There are three main highlights in this case. First, whether the employee was dismissed without just cause or excuse, which is wrongful dismissal. Second, whether the employer follow procedural fairness, meaning proper notice, inquiry, and communications. And third, whether the principle of natural justice was respected, where the employee must be given a fair chance to defend himself before being terminated. These are the three key issues that the Industrial Court examined when deciding the case. The research method used in this assignment is doctrinal legal research. This is a library-based method where we examine statute, court cases, and legal journals. Through this method, we can better understand how the Industrial Court applies the law to real disputes, such as in these cases between Winston and 7 Autospa. Citation of the case. The case is officially cited as Winston Tang Chun Leong against 7 Autospa Holdings Sdn Bhd. It was reported in the Industrial Law Journal 2025 at page 1081 with the case number 7/41362/23. This case was heard at the Industrial Court in Kuala Lumpur by Chairwoman Puan Vanitamani Sivalingam. From this slide, we can see the fact of the case. To summarize the fact, Winston was hired, later promoted, but then on 15 January 2023, he was verbally dismissed by his manager without any official termination letter. Afterward, he tried to get clarification, first by sending an email, then later through his lawyer. But the company denied that he was dismissed. Instead, the company accused him of insubordination and abandonment of work. Finally, after reviewing the evidence, the court ruled that the dismissal had indeed taken place and it was unjust. Winston joined the company on 10 January 2022 as head of Tinted. Later, in August 2022, he was promoted to executive director. An executive director, his responsibilities were largest. He had to manage operations and supervise other staff members. This shows that Winston was not just an ordinary employee, but someone who held a key position in the company. On 15 January 2023, Winston received a phone call from his manager, Andy. During the call, Andy told him directly not to return to work from the next day onward. What is important to note is that there was no official termination letter issued. Everything was only told verbally over the phone. This became a crucial fact in the case because the dismissal was not properly documented. After receiving the phone call, Winston tried to clarify his situation. On 17 January, he sent an email to the company, but no reply was given. On 27 January, his lawyer issued a letter of demand. On 3 February, the company responded, but they denied that any dismissal had taken place. Because of this, Winston decided to file a representation under Section 20 of the Industrial Relations Act 1967, claiming that he had been unfairly dismissed. In its defense, the company argued that Winston abandoned his job. They claimed he was absent on 14 and 15 January, applied for 11 days of Chinese New Year leave but was only given 3, requested a salary advance which was rejected, and even arranged for someone else to punch his attendance card. However, the court found this claim inconsistent. Being absent for 2 days does not prove abandonment of work. The court confirmed that an oral dismissal had indeed taken place. Since the company failed to prove just cause, the court ruled the dismissal was unjust. This case shows the importance of employers following proper legal procedure when dismissing employees. If they fail to do so, the dismissal can be ruled unfair and the employee will be entitled to remedies such as compensation. That's end my part of the presentation. I will now hand over to my teammate who will continue with the issues and judgment of the case.
The core issues identified are just cause and excuse, which place the burden of proof on the employer once dismissal is established. Constructive dismissal, which occurs when the employer's conduct effectively forces the employee to resign or terminate their contract. And abandonment of employment, where mere absence does not automatically constitute desertion. Just cause and excuse entails that the employer must prove with both substantive and procedural fairness that the termination was warranted due to misconduct, inadequate performance, or other legally accepted justification. The court underscores that the employer bears the responsibility to demonstrate just cause or excuse. Otherwise, the dismissal would be deemed unjustified or unconstitutional. A lack of simultaneous evidence of wrongdoing or duty violation, together with an absence of formal procedure, makes the termination capricious and untenable under established labor law. Constructive dismissal occurs when an employee is effectively forced to resign due to the employer's actions that significantly violate the employment contract. The court recognized that intentional delay, neglecting to address grievance, or behavior indicating a desire to no longer adhere to the contract may amount to constructive dismissal. Abandonment of employment arises when an employee is absent without lawful justification for an extended period. Yet, the absence alone does not automatically amount to desertion. The court notes that absence must be weighed alongside other factors such as intent, communication, and evidence of abandonment. Mere absence without corroborating actions or communication does not automatically justify a finding of abandonment. Employers must present clear evidence that the employee intended to abandon the job, such as a prolonged unexcused absence and explicit act signaling desertion, to sustain a claim of abandonment. Turning to court's findings, the claimant was dismissed verbally, while the company failed to prove abandonment of employment, and the dismissal was found to be without just cause or excuse. The HR department's failure to provide written warnings, the unjustified denial of leave and pay advances, and the termination without appropriate notice or due process contributed to the determination of unjustified dismissal. The dismissal occurred verbally without formal written documentation or an official letter, which weakens the procedural framework and evidentiary support for the employer's asserted grounds for dismissal. The court found that 2 days of absence did not amount to job abandonment. The company's evidence was insufficient to prove that the claimant had abandoned employment. The dismissal was deemed to be without just cause or excuse due to the lack of a valid justification and the absence of due process, including written warnings and a formal termination. An award is discussed in the context of the industrial court's compensation framework, with particular reference to the 62,300 ringgit Malaysia award from the Winston Tang case as an illustrative remedy when dismissal is unjustified, grounded in Section 30 subsection 5 of the Industrial Relations Act 1967.
I'm Lau Yok Lian. Now this is my turn to present the PPT. In my part, I will focus on the related topic and law connected to this case. We are looking at three main issues: the significance of formal letters and notices, the importance of procedural fairness, and the burden of proof in dismissals disputes. Alongside this, I will also explain the main laws that apply, which are the Employment Act 1955, the Industrial Relations Act 1967, and the Industrial Court Rules of 1967. These are very important because they decide whether a termination is lawful or unlawful. If an employer ignores procedures or fails to follow the law, it can weaken their case in front of the industrial court. So let us look at each part more closely. One of the first issue in this case is the absence of proper formal letter and notices. Under employment law, an employer cannot just dismiss or punish a worker verbally. All disciplinary action, suspensions, or terminations must be put in writing. This ensures transparency. It gives the employee the opportunity to respond, and it protects fairness in the workplace. In this case, the employer failed to follow this basic step. For example, Mr. Andy only told the claimant verbally not to report to work on 15 January 2023. No written termination letter was given. Later, the company only responded after the claimant's lawyer sent a demand letter, which shows poor communication. And finally, when the company accused the employee of abandoning work, no warning letter was issued. Or this missing document clearly weakens the employer's legal standing. Without written evidence, the company cannot prove that it acted fairly or according to law. The second issue is procedural fairness. This principle means that every employee must be given a fair chance to be heard before any action is taken. An employer should not rush into termination. Instead, the correct steps are issue a show cause letter, give the employee the opportunity to explain, and if necessary, suspend the worker while conducting an inquiry. If an employer ignores this step, it becomes a violation of natural justice. Natural justice is the idea that decision must be made fairly without bias and with respect for the rights of both parties. In this case, because the company dismissed the worker without giving him this opportunity, it shows that procedural fairness was not followed. This makes the termination unlawful. The third issue is the burden of proof. In dismissal cases, the law is very clear about who must prove what. First, the employee must prove that a dismissal actually took place. Once that is shown, the responsibility shifts to the employer. The employer must then prove that the dismissals were justified and based on just cause or excuse. This means the employer must provide documentary evidence such as letter, notices, or proper records, as well as reliable witness testimony. If the employer only makes verbal claims or relief on unsubstantial accusation, it will not be enough. In this case, because the company did not have the proper documents or procedures, it becomes very difficult for them to prove that the dismissal was lawful. Now let us look at the law. We have some related law here, the Employment Act of 1955 and the Industrial Relations Act of 1967, the Industrial Court Rules of 1967. Okay. The Employment Act 1955, this law covers important rules about termination of employment. Section 12 requires proper notice periods. The notice length depends on how long the employees have worked. 4 weeks if less than 2 years, 6 weeks if between 2 and 5 years, and 8 weeks if more than 5 years. Section 13 allows termination without notice only if the other party is compensated with indemnity. Section 14 says that if there is misconduct, the employer can only dismiss after a proper domestic inquiry is held. Section 14 also allows suspension, but only up to 2 weeks, and with at least half salary pay. Section 15 states that if an employee is absent for more than 2 days without permission or a valid reason, it may be considered a breach of contract. So the act is clear. Termination cannot be done suddenly or unfairly. Procedural and notice period must be followed. Okay, let us consider the Industrial Relations Act 1967 and the Industrial Court Rules of 1967. Section 20 of the Industrial Relations Act allows any employee who believe they were dismissed without just cause or excuse to file a representation with the Director General. If the matter cannot be resolved, it will be referred to the Industrial Court. The court has the power to order reinstatement or compensation. Importantly, Section 30 tells the court to act according to equity, good conscience, and the substantial merits of the case, not just strict technicalities. This means the court looks at fairness and justice, not only paperwork. The Industrial Court Rules of 1967 set out how cases are managed. They make sure both parties have equal chances to present documents, give evidence, and make argument. These rules help maintain justice by ensuring that cases are handled in an organized and fair way. So in this case, this law and rules together provide strong protection for employees who face unfair dismissal. They remind employers that any action must be transparent, justified, and in line with proper legal procedure. In conclusion, we see that the absence of formal letter, the violation of procedural fairness, and the failure to meet the burden of proof of all points to witnesses in the employer's case, the Employment Act 1955, the Industrial Relations Act 1967, and the Industrial Court Rules of 1967 set very clear standards for fairness, transparency, and due process. Employers who fail to follow these rules will face legal consequences. Okay, this is all for my presentation. Now I will pass the presentation to Mr. Haikal. Thank you.
Hello, my name is Haikal and I will show you my presentation today. The first related case is 7.1 Wo Chie Hong vs. Cathay Organization and 7.2 Wong Yun Hock vs. Shaika Hong Leong is second case. And the last one, 7.3 Gon Kiew Poi vs. JNP Codes. In the fact of case 7.1 Wo Chie Hong vs. Cathay Organization is the employee assisted he was terminated without justification, while the employer contended he had voluntarily quit. The question was whether a dismissal had indeed conspired. And the result of judgment, the federal court determined that dismissal included both express and constructive dismissal. The court determined that the onus is on the employer to provide reasonable cause or justification once dismissal is confirmed. And second case is 7.2 Wong Yun Hock vs. Shaika Hong Leong. The fact is the claimant assisted constructive dismissal due to the employer conduct rendering continued employment untenable. And the judgment say the Court of Appeal affirmed that dismissal may transpire without official termination letters if the employer's action constitute a fundamental violation of contract that erodes mutual trust. And the last one is 7.3 Gon Kiew Poi vs. JNP Codes. The fact is the employee was terminated and the question was whether the termination was warranted. The result of judgment, the federal court ruled that after dismissal is established, the employer must provide just cause or justification, else the dismissal will be considered unjust. This notion has emerged as a fundamental tenet in Malaysian industry law. The first comparison case, which is 7.1 Wong Chie Hong vs. Cathay Organization, is both instances demonstrate that the instance of employer conduct supersedes its form, underscoring the industrial court's function in protecting worker right against arbitrary termination irrespective of whether the dismissal was documented in writing. And the comparison of the second case, which is 7.2 Wong Yun Hock vs. Shaika Hong Leong. Both cases underscore that the factual condition and action of the employer are crucial in ascertaining whether a dismissal has transpired. Furthermore, once dismissal is proven, the onus shifts to the employer to demonstrate that it was justified or excusable. This example highlights the industrial court emphasis on substantive fairness rather than procedural formality. There will be strengthening safeguards against unjust termination. The comparison of the last case, which is 7.3 Gonqiu Poi versus JNP Courts. Both examples highlight the significance of substantive fairness in industrial dismissal issue and demonstrate that the industrial court must evaluate the entirety of evidence, including oral testimony and documented evidence, to ascertain the legality of the dismissal. The Gonqiu Poi doctrine constitutes a fundamental legal basis in the rationale of the Winston judgment. And thank you.
Assalamualaikum, good evening. Today I'm going to present for my group 1 for the conclusion and also for the reference. So without wasting our time, let's go jump to the conclusions. These cases show the importance of understanding the employment right and fairness in the working place. Yes, the claimant made a minor mistake. However, the employer failure to follow proper procedure was more serious. The evidence supported the claimant, and the final decision ensured a fair and balanced justice for both sides, the claimant and also for the employer. Let's go for the first point. Understanding of employment rights. The claimant had a notable understanding of his right as an employer under Malaysian industrial legislations. In the absence of formal legislator, he proactively sought clarity from his superior, requested an official termination notice, and filed a claim with the industrial court. It's become out of proportion when the manager or his superior failed to give it an official termination notice to his claimant. The second one is claimant misconduct and technical violations. This is the minor mistake that made by the claimant. Although the claimant was not wholly blameless, specifically for his unauthorized absence and asking for a colleague to clock in for him, this conduct was inappropriate. Again, this is a small mistake made by the claimant were insufficient to warrant dismissal. The wrongdoing seemed to be small and situational rather than intentional or egregious. The employer procedural deficiency surpassed the employer's error. The employer conduct demonstrated considerable procedural and substantive shortcomings. The oral directive against returning to work, along with the absence of written paperwork or a true investigation, compromise the validity of their sentence. The court correctly determined that the employer failed to meet the burden of proof necessary to demonstrate a decent or reasonable cause or justifications. The evidential weight supported the claimant position. The court favored the claimant account over the opposing narrative, attributing this preference to the claimant documented attempts to engage with the employer, the absence of conflicting information from the company, the lack of any formal disciplinary proceeding. This is the excusable and also symbolic regress. This case study highlights the necessity of preventing the legal professional to manage workplace disputes. as a regular employees may feel disheartened or inadequate in pursuing remedy, particularly when they perceive their own potential error. The Vincent case illustrates that with adequate legal assistance, the claimant who may have made an error in specific area can not less attain a fair hearing. So these are the few references that we use for this assignment. First, we take from the book, and also we take from the journal, and then we take from the online sources, for example, the e-law sources. Yes, the e-law sources for the Employment Act 1955. And then we have a case law here, recent Tan Chong Doos versus 7 Autos Holdings in Berhad, and also Wong Ching Hong versus KT Organization. There's a few case law here. Yes, that's all for my presentation today, and Assalamualaikum.